Okay, folks, the judge has called about a half-an-hour break in the Whaley case out of Iowa. This is a case involving a man who basically opened fire when he heard someone outside his door. It turned out to be someone who had been at his house earlier and who is coming back apparently to retrieve a bicycle sometime around 3:30 in the morning. She even had a key, but he claims that he thought that it was an old roommate of his who had a gun and a propensity for violence and was afraid that he was in harm. Julie Rendelman, Law and Crime trial analyst. I'll leave out the other two titles. Well, it's because I'm used to saying 3 titles and you tell me I can only use one.
We're very impressed with you.
So I have to stop and rewind my brain. Anyway, do you buy this guy's story or not?
I buy the story. I don't know that it amounts to him getting off the hook, though. I think that, look, when you listen to the story, I certainly don't think he intended to kill the young woman that got killed. I think that he thought, perhaps, whether, I don't know why he necessarily thought it, but that someone else potentially was coming to the house, whether it be the woman's stalking boyfriend or this ex-roommate, and acted upon it. I don't know that that takes you out of criminal liability, though, for your acts.
I don't think so. At least it doesn't seem to me that it should. Look, I mean, have we, and I asked this question yesterday, I'll ask it of you, have we become a society where people hear a sound outside their door and then they just start unloading their guns?
Well, I mean, look, I don't want to get into the whole debate about guns and who should have them and who shouldn't, but, the question you have to ask, if he didn't have a gun and wasn't able to purchase a gun, would these events have happened? And we've talked about this on many different occasions, on many different cases, including the incident that we once had with regards to the case that happened at the campus where the young man shot at a group of kids. So, no gun, this wouldn't have happened, but he had a gun, and to me the question becomes, whether or not he was justified. And I don't believe under the law that the jury's going to find him justified. The question is whether this amounts to murder or some type of manslaughter.
Well, it seems from what I've heard that under Iowa law, this second-degree murder is sort of the catch-all in that state that handles just about everything.
It really isn't, though. The murder, too, really is, they call it malice aforethought or whatever, which is basically, did he commit an intentional murder? I think the murder one, unless I'm reading it wrong, in Iowa, talks about several factors, including the need for premeditation. And so it looks to me like murder 2 is basically intent without that premeditation. But you also have the options of the lesser inclusive manslaughter, which are also possibilities in these cases.
Well, certainly the prosecutor is going to charge the top charge that the prosecutor thinks might even possibly stick. There's no evidence of premeditation
Absolutely
here.
None.
So the murder 1, which was the original charge in which they knocked back down, is obviously off the table here. So now we're in the land of potentially second-degree murder. Maybe, if I'm to buy your argument that there's no intent,
I'm not even throwing the argument out there. I'm saying that a jury, look, sometimes a jury doesn't buy that there's self-defense, but nullifies and says, well, there wasn't self-defense, but there really wasn't an intent to kill, and so therefore they reduce it to the one of the manslaughters. That's always a possibility with the jury.
So firing the bullet through the door isn't intent to kill.
Well, again, I'm not arguing that it's not
a squirrel out there.
I'm not arguing that it's, well, look, in order to make a determination of intent, how do you figure out what's in a person's mind? Because obviously he's usually not going to announce he's about to intentionally kill someone when he kills someone. And so usually the law allows you to kind of read into the acts of the defendant kind of before he acted, when he acted, and kind of the result that occurred from what he did. So yeah, when you shoot a loaded firearm towards any potential person and the result is death, one can argue that you can assume that their intent was to kill the individual that was on the other side. My argument is if the jury doesn't buy self-defense but still thinks, well, he didn't mean for her to die, they can nullify. They can go, you know what, let's give him a break. That's more what I'm talking about than the actual legalities of a lesser included of murder. And keep in mind just one thing, just so we're clear, murder 2 that we're talking about here is kind of the typical murder, the top murder count in New York. That's what we deal with almost all the time because We don't have premeditated murder in New York. We have mostly murder twos with certain exceptions, i.e. police officers that are killed and whatnot. So the murder two is usually kind of the catch-all for most states.
Or the punishment is different.
Sure, exactly.
Depending on
absolutely
on whether or not it's someone specifically targeted. For instance, a police officer,
exactly.
a judge, a member of government, something like that.
Right.
But let's, as we wait for court to come back into session, review some of the earlier testimony this afternoon. We're going to dip back into the testimony of the investigator who was on the stand for most of the early afternoon. We'll be back in a bit.
Investigator Prohaska, right before lunch, we were talking about being at the Mason City Police Department on the early morning hours of December 2nd. At some point, did you get a chance to interview the defendant, Larry Whaley?
Yes, sir.
Was that at one of the interview rooms at the Mason City Police Department?
Yes, it was.
And approximately how long was the interview?
Several hours with breaks.
During the interview or at breaks, did you offer the defendant any food or water?
Yes, I did.
At the beginning of the interview, did you read the defendant his Miranda rights again?
Yes, I did.
At what time in the morning approximately did the interview start?
It was about 6:30 in the morning, I believe.
And at this time, did you have limited information on what happened?
Yes, I did.
Did you ask the defendant for a phone number?
Yes, I did.
When I say a phone number, did you ask if he had a cell phone number?
Yes, sir.
Did he give you a number?
Yes, 641-530-5817.
Did you ask the defendant if he had been in the military or did he volunteer that?
Yes, sir. He said he was in the Marines years ago.
A retired Marine?
Yes, sir.
Did you ask the defendant why he was at the Mason City Police Department?
Yes, I did.
What did he say?
He said he felt threatened all week.
Did the defendant expand on that? Did he say who he felt threatened by?
Yes, he said he felt threatened by his former tenant or roommate, and also Deb Ewing's ex-boyfriend.
Did the defendant say who his former tenant was?
Yes, Corey Mays.
Did the defendant tell you who Deb Ewing's ex-boyfriend was?
Yes, he did. Jason Ben Dixon.
Did you ask the defendant if he knew Deb Ewing?
Yes, I did.
What did he say?
He said he knew her about 3 weeks.
Did the defendant say how he knew Deb Ewing?
He said he met her 3 weeks ago. He mentioned that she was homeless and that he was going to allow her to move in with him and show her a better way of life.
Did the defendant say anything else about feeling if he had felt threatened by Corey?
Yes, he went on to say that that Corey had lost his cell phone and that Larry, he was blaming Larry for taking it.
Did the defendant say anything about Corey having a key to the defendant's apartment?
Yes, he said he believed that Corey, who used to live with him, duplicated a key to his apartment.
Did the defendant make any statement how he felt about these threats being done during the week?
He said he was, I guess in his words, sick of them. He was fed up with the threats. Excuse me, I'm battling a cold, so I may clear my throat a lot.
Do you need any more water again?
I guess I probably need a refill before we're done.
Let me know.
Thanks.
Investigator Prohaska, at some point, did you ask the defendant about a gun?
Yes, I did.
What did the defendant say about a gun?
He said he purchased a gun. He said that he met a friend or had a friend named Jeff, and who introduced him to a person that could sell him a gun, and identified by the first name of Charles. He said that he contacted Charles, who lives in Charles City, and Charles agreed to bring a gun over to Mason City to sell him. Just before dark on December 1st, Deb Ewing and the defendant met with Charles to purchase the gun. The defendant said that during that purchase, Charles offered to sell him a rifle, a 30-30 or a 30-06. He wasn't clear on that, but the defendant chose to purchase the handgun, a .44 Magnum revolver. He paid $500 for it.
Just going to ask you, the defendant told you he paid $500 for it?
Yes, sir.
Did the defendant say after purchasing the gun that if he picked anybody up?
Let's see. After he purchased the gun, they went to. After they purchased the gun, I think Caleb, I'm pretty sure that's when Caleb and Sam rode their bikes over to his house, and Larry agreed to allow them to lock him up in his garage.
And during the interview, did the defendant, Mr. Whaley, refer to Caleb by a nickname?
Yeah, Kid, I believe is what.
So he told you that Caleb and Sammy rode their bikes to his house and put him where?
In his garage.
And he told you, Mr. Whaley said they locked him up?
Yes, sir.
Did the defendant, Mr. Whaley, say where they went after that?
Yes, he said they traveled to Keith Reiser's house on 9th Street.
Did he say who was all in the car at that time?
Yep, Caleb, Kid, Sammy, and Deb, along with the defendant.
At some point, did he say if they left Keith Reiser's place and went somewhere else?
Yes, they said after they visited with Keith Reiser, they all got back in Larry's car, and they went to Walmart.
Did the defendant say why during this interview he went to Walmart?
Yes.
What did he tell you? I'm sorry.
He said two reasons. One was to purchase Deb a new phone, and the second was to buy bullets for the revolver he had just purchased.
Should have backed up. When the defendant told you about buying the gun, did you ask the defendant why he got a gun?
Yes.
What did the defendant say to why he bought a gun?
That he felt threatened and it would offer protection for himself.
So going back to Walmart, so he said they went to the Walmart for the two things, the phone and the bullets?
Yes, sir.
Did the defendant say who went inside?
Yes, he said that Caleb, Samantha, and Deb all went inside, and that Caleb came back out. Samantha and Deb stayed inside Walmart and purchased the cell phone along with a box of .44 caliber bullets together.
Did the defendant say who paid for the items? In other words, who gave the money to get the two items?
The defendant said he gave the money to Deb to pay for the items.
Did the defendant say what he did after Sammy and Deb came back from Walmart? Did they buy the two items?
Yes, he said they got back in the car. Deb had a new phone, and Deb gave him the box of bullets in a green box, and they loaded the weapon then. Larry did.
The defendant said he loaded the revolver?
Yes, sir.
Did the defendant say where they went after Walmart?
Yes, he said they drove over to a friend's house on 3rd Street, or to visit with a friend named Jenny on 3rd Street. They ended up picking her up, and they all went back to Keith Reiser's house on 9th Street together.
So all 5 went to Keith Reiser's house?
Yes, sir.
Did the defendant say if anybody left Keith Reiser's house?
Yeah, he said after they were there for a short time, himself and Deb decided to go get a hotel room at the Days Inn in Mason City.
Did you ask the defendant why he got a hotel room?
Yes, he got a hotel room because he wanted to protect Deb from Jason Ben Dixon, who they were told that was looking for Deb.
Did the defendant say if they stayed at the hotel room the rest of the night?
Yes, he said that Deb took a shower, they freshened up a bit, and Deb had decided that she wanted to just spend the night at his apartment rather than the hotel room.
Did the defendant say where they went after they left the hotel room?
Yep, he said they went back to Keith Reiser's house.
Did the defendant say if they picked anybody up there?
Yes, sir. They picked up Caleb and Samantha and also Jenny. Picked them up, and they ran Jenny back home up. I don't believe it was her home. It was a friend of hers, and they dropped her off there, and then went back to Larry's apartment.
So the defendant told you after Deb and the defendant left the Days Inn, they went back to Keith's place?
Yes, sir.
Picked up Jenny, who else?
Samantha and Caleb.
And then they dropped Jenny off?
Jenny off on 3rd Street.
Then the defendant, Deb, Caleb, and Sammy went where?
They all traveled back to Larry's apartment.
Did the defendant say what happened when they got back to his apartment?
Yes, sir.
What did he tell you?
He told me that he decided to stay in the car and go visit a friend. So he took his key and he gave it to Caleb and told them to go into his apartment, meaning Deb, Samantha, and Caleb.
So the defendant told you he stayed in the car at that point?
Yes, sir.
And after giving Caleb the key, did he say who got out of the car?
Yes, sir. He said that all 3 of them got out and walked into the apartment.
Did you ask the defendant at that time who all had keys to his apartment, or during the interview did you ask him that?
Yes, sir.
What did the defendant say about who had keys to his apartment?
He started off by saying he had his key, the one he just had given Caleb. He believed that Corey Mays had a key, and he believed that his landlord had a key as well.
Did the defendant say where he went after he dropped the 3 off?
Yes, sir.
What did he tell you?
Again, back to Keith Reiser's house. He said he stopped there briefly, and then he traveled back to Jenny, where he dropped off Jenny to visit with her.
Did the defendant say where he went after he went to where Jenny was staying?
Yeah, after he left Jenny's, he went to Walmart again.
Did the defendant say why he went back to Walmart?
Yep. Yes, sir. He described he went back to Walmart to purchase a flat screen TV for his apartment, and he also purchased several food items.
Did the defendant, after leaving Walmart the second time, say where he went?
Yes.
Where did he tell you he went?
He said he then traveled back to his apartment on 17th Street.
When the defendant got back to his apartment after his second trip to Walmart, did the defendant tell you if anybody was in his apartment?
Yes, he said when he got back to his apartment that Deb Ewing was in his apartment, and that Deb had told him that Samantha and Caleb got into a small argument and they left, and then he said that Deb had told him that Samantha was coming back.
So the defendant during this interview did tell you that
Yes, sir.
Deb said that Sammy was coming back?
Yes, sir.
Did the defendant talk about placing any items by a door?
Yes, sir.
What did he say?
The defendant said after he got into his apartment and locked the door, he placed kitchen knives in the door jamb to secure it shut. Even if you had a key, it would prevent the door from opening.
I want to show you a couple of photographs. May I approach, Your Honor?
Yes.
First, I'm going to start with pull up State Exhibit 40. Investigator Prohaska, it's been described by investigators. There were a couple of knives found, and the diagram shows where in Mr. Whaley's apartment on the floor. Do you see that?
Yes, sir.
Okay. Then I want to put up State's Exhibit number 32. Do you recognize this photograph?
Yes, that's the door jamb where the knives were stuck in.
Okay. And when you say it's the door jamb, first I'm going to, if I may have permission from the court for Mr. Dalen to be able to move the door so we can describe how this is done.
That'd be fine. And then, Mr. Dalen, when you're done, if you could maybe set the door down so it's not blocking the court's view of the screen, that'd be appreciated.
And Your Honor, if I may have permission for Investigator Prohaska to come down, I think it might be easier if he shows the jury.
That's fine.
Investigator Prohaska, when the defendant was describing putting knives in the door, can you explain what we're talking about?
Yeah, bear with me, my hands, the knife. Very described putting the knives in the door like this. That's how he would prevent the door from opening up. Like that's going on. There's two knives right about this area.
Go ahead, I'm sorry.
It's similar to like somebody, if you've been to a hotel where you have that basically the same principle we do with the knives.
And I'll have Mr. Dalen move the door before you sit down. Then I'll have you refer to State's Exhibit 32. Mr. Dalen, I think you want it on the side if you could.
On its side.
Investigator, I'm sorry, just a second. I'll let Mr. Dalen finishes here.
It's okay.
I appreciate that, Mr. Dalen. I didn't realize you'd be doing moving duty today, but
Investigator Prohaska, looking at State's Exhibit 32, were you able to see any impressions in the door jamb that were consistent with the blades of knives? Would you show the jury what you're looking at?
Right here, you can see the dark slit. It's hard to see, but there's a couple of impressions into the door here, right where the few pieces of wood meet together, trim, and there's very distinct slits in those doors.
And that, you said, would prevent a person from opening the door from the outside? Thank you. You may have a seat. The interview, Investigator Prohaska, you were talking about the defendant got home from Walmart, and you told us about the conversation with Deb Ewing and what happened there. Did the defendant then say after he got home when he put the knives in the door jamb?
Yeah, immediately after he got home, he described putting the knives in the door jamb.
Did the defendant say what he did after that?
Yeah, he said he there's a long couch along the east wall. He said he sat with Deb down on the couch with his gun.
So the defendant told you he was sitting on the couch and he had his gun with him?
Yes, sir.
While he was sitting on the couch, did the defendant tell you if he heard or saw anything?
Yes.
What did the defendant tell you?
He said he saw the doorknob starting to move. He said when he saw the doorknob starting to move, he leaned over and told Deb what he was seeing, and then he said he heard knocking at the door.
So the defendant told you he heard knocking at the door.
Yes, sir.
Let me back up. May I approach?
Yes.
I'm going to hold up State's Exhibit 65. Investigator Prohaska, are you able to see that okay?
Yes, sir.
You see where there's a number 2 and there's a couch?
Yes, sir.
That represents there was a couch in the defendant's apartment. You see that?
Yes, sir.
Had you been into the defendant's apartment after this interview?
Yes, sir.
And was the couch still there?
Yes, sir.
And from the sitting on the couch, could you see the door?
No.
Why not?
I physically sat in the door exactly where Larry described, and, or excuse me, on the couch.
A laser pointer.
Yes.
Push down on the red button here.
Okay, got it.
Okay, we'll go back to State's Exhibit 65.
I sat there. I knew the couch hadn't been moved because in the carpet you could see the impressions where the legs were still. Yeah, many of you know if you've ever vacuumed, it's hard to get those out. So they were there. So I was sure that the couch was in the same spot. So I sat in Larry's position, and there was no way I could see the doorknob at all without getting up.
Investigator Prohaska, going back just for a second to, you talked about the knives the defendant described. Is this what the defendant's describing to you?
Yes, sir.
Because when you were at the apartment, the knives were no longer in the door.
No.
So you're just telling us what the defendant told you during this interview?
Yes, sir.
All right. And the defendant told you, he said he saw the knob moving from the couch is what he told you.
Yes, sir.
Is that when he said he heard knocking at the door?
Yes, sir.
So after the defendant heard knocking at the door, what did he say he did?
He said he got up and walked over to the door and shot through it.
Did the defendant say if he saw anything going on to the door before he fired a shot?
Yes, he did.
What did he say?
He said he now saw the top lock being manipulated.
So the defendant got up, walked over. Did he say how close to the door he got?
We were in an interview room, which is about 10 by 10, and he stood at I asked him, I put a chair up to pretend it was the door, and so I would say he stood where he thought he was, and it was about 5 feet or so.
So the defendant showed you he was about approximately 5 feet away, and he said he saw the top lock being manipulated?
Yes.
Did the defendant say what he did next?
Yes, he said he yelled to get back from the door and fired 2 more rounds to the right of the door.
And I need to back up, and that's my fault. So, earlier you talked about a shot being fired?
Yes.
So I just want to make sure the sequence is right. So the defendant's on the couch, and he says he sees the doorknob moving.
Yes.
Then he said he got up,
Yes.
or he heard knocking,
Yes.
and then he gets up.
Correct.
Did the defendant say whether the first shot happened before he saw the top lock being manipulated or after the?
The first shot was, I believe it was, he saw he fired the first shot before he saw the top lock being manipulated, is what I believe he said.
And where did he say he fired the first shot?
Through the door is what he said, in his own words.
Did you ask the defendant why he fired the first shot through the door?
Yes, he said it was a warning shot.
So after the defendant said he fired the first shot, what did he see or hear next?
He said he yelled to get back from the door, and he saw the top lock being manipulated, and he said he thought the door started to open just briefly a little bit, and he fired 2 more rounds to the right side of the door. During the interview, he described them as pow pow.
Was there a delay? Did the defendant describe a delay between the first shot and the second and third shot?
Yes.
And he said the second and third shot were farther to the right?
Yes.
Did you ask the defendant why he fired those 2 shots?
Yes, he said they were warning shots again.
Did you ask the defendant if the door ever opened?
Yes.
What did he say?
He said it never opened.
Did he say if the knife stayed in or had fallen out?
No, he described the knife stayed in the entire time.
Did you ask the defendant who was on the other side of the door?
Yes.
What did he say?
He said he didn't know. Then he said he thought it was Corey.
We were reviewing testimony there from Investigator Prohaska. He was on the stand through most of the afternoon, and we're in the midst of what the judge called about a half-hour break. Right now we're looking at a picture of the defendant sitting on the defense table with his attorneys talking. It doesn't look like they're ready to come back into session anytime soon. Julie Rendelman is still here with me. Julie, we're talking about whether or not this defendant's excuse, if you will, is going to be strong enough to get him past the second-degree murder charge or potentially a lesser included charge. I don't think that what he did was reasonable, and that's the key word in the law.
I don't disagree with you, and I think that, again, let me be clear about what I keep saying, which is if the jury follows the law, I think they are probably obligated to find him guilty of the murder to count. However, I do think, just like any jury, they have a right, if they want to find him guilty instead of one of the lesser included counts. And I say that because even though I think that at the end of the day there is clear evidence that he intended, obviously by firing a weapon numerous times through a door, intended to kill whoever it was that was behind the door, I think the jury can, if they want to, say, you know what, he didn't intend to kill her, and because of perhaps whatever concerns he had about the fear of the other individuals that he thought were coming in, and whatever else was going on, that maybe there is some kind of level of mitigation. Doesn't mean they're following the law, but a lot of jurors don't follow the law when it comes to making a decision of this importance.
Well, I mean, or they just might look and say, look, there's a young woman who's dead here. We just can't excuse what happened.
I agree with it can be either, and I agree with you. I just, one wonders what perhaps, I don't know if he was on drugs at the time, or certainly
there's evidence of some drugs in the apartment.
Well, certainly there's evidence that the other young woman that was in the apartment was on drugs. So one would wonder if he was in fact as well, just because some of the behavior seems incredibly paranoid in terms of A, the purchase of a gun, B, the fact that he had knives like guarding the door, and C, even the fact that he didn't kind of have the wherewithal to even recall or be cognizant of the fact that it was possible that someone coming to the door would have been someone that he gave a key to before, which kind of adds another kind of element
he gave her
to
the
these
key,
issues.
But and I gotta wonder though. This thing happened at 3:30 in the morning. Do you really think somebody who's got a key to your place is going to show up at 3:30 in the morning?
No, but that doesn't mean you're allowed to shoot through the door.
Well, of course not. Of course not.
No, but that's kind of what we talk about the jury kind of going, I see the intent. I don't believe it's justified, but is there something that we can find him guilty of that's less than the intentional murder?
I don't know. I mean, I don't know if the jury would be willing to pare this one down. And he had these knives wedged in the door to try to make it harder to open, and he's trying to use that as evidence that, hey, look, he was fearing that people were going to come in and do something to him.
Right, but the issue becomes, and obviously in Iowa the issue is whether a reasonable person in his position would have foreseen that or would have believed that there was a potential deadly physical force coming at him that would have allowed him to use the deadly force. And that's the problem, is someone simply trying to open your door does not rise to the level potentially of deadly physical force. With that said, I think that a lot of people, when they're in some people believe that when you're in your home is kind of your sanctity, and so therefore you're allowed to use kind of that extra force to protect yourself or anyone else that's in the home.
Well, yeah, but it has to be reasonable too.
Exactly.
I mean, Iowa's got the castle doctrine, from what I understand, but it also has a caveat that the use of force has to be reasonable. It has to be judged sort of dispassionately.
Right. Right. No. That's where the problem is. And again, I'm not.
In other words, is it reasonable to open fire without knowing who's on the other side of the door? Do you at least wait a split second for the door to open? And if it's really somebody who's out to get you, if that's what had happened here, we wouldn't even.
This is becoming the theme of many cases that we hear about. With kind of the stand your ground and all those things. I don't think it's reasonable. I don't think you think it's reasonable. I don't know that a jury's going to think it's reasonable. But again, I don't believe he has a pure justification defense in this case. The question is whether the jury's going to believe he acted with the intent to kill at that time.
We're going to continue to review some of the testimony from earlier in the case. Let's dial back to what we heard first thing this morning. We'll be back in live court as soon as court resumes.